What it do, what it do, what it do. It's your boy Big Val Opinion back with another live video. Make sure you hit that like button. Make sure you hit that share button. And most importantly, make sure you sub to the channel. Turn on that post notification bell so that you be notified each and every time that your boy Big Val is going live, man. With that being said, let's get into this intro.
For introducing the testimony of the three uncharged victims.
The testimony of Young, Dunning, and Wolf, as Justice Burke found, was directly probative of defendant's state of mind.
Why wasn't that accomplished with the three women who were complainants? I mean, that for me is the problem. You already have three women who give you three different types of stories of the horrors they experienced with him. I think you've covered that. So to pile on with three uncharged complainants, three uncharged victims, is leaning really close to that propensity line.
It was relevant to defendant's intent. As Your Honor pointed out, intent was hotly contested below.
I don't understand how that wasn't established through man.
Because
we had a 5-year relationship with him after the assault.
Because Mann's allegations were not so unambiguous that there would have been no doubt in a juror's mind that defendant intended the forcible element of the first-degree rape. Again, when Justice Burke...
You're saying that you wanted to prove what he did with Mann by introducing the testimony of those other three women.
No, certainly not. Mann's allegations would have established, if believed, would have established the elements of the offense.
Where the women were of the uncharged crimes were not the victims for which were being prosecuted, though. Where was the balancing that's supposed to go on in Molyneux? This was incredibly prejudicial testimony, no?
Well, no, respectfully, Your Honor, it wasn't prejudicial for two reasons. One, the court gave extensive limiting instructions. 3 times the court explained to the jury...
The fact that there's instructions doesn't mean it's not prejudicial.
But here we know it wasn't.
I'm being charged with 3 rapes. And here come 3 other women who claim I did the same thing to them, but I'm not being charged with that. That's prejudicial.
Well, it's not prejudicial.
So the question is, does that prejudice, is that outweighed by some probative value that supersedes that?
Respectfully, Your Honor, it wasn't prejudicial here, and we know that.
Opposing counsel referred to the Molyneux rulings in this case as unprecedented. What cases do you rely on under New York law that actually constitute precedent for the court's rulings in this case on the Molyneux issues?
Well, parsing the Molyneux evidence, no one would quibble with the admissibility of the uncharged offenses as to Mann. Ample case law, which we...
I'm talking about the other 3 women.
Right. As to Young, Dunning, and Wolf, again, I think Vargas is a perfect illustration of precisely why we were permitted to put forth the evidence here. It's well understood that Molyneux evidence can shed light on a defendant's state of mind and intent.
So you're really arguing that this was not overkill? I mean, there were certain items in the Sandoval that I thought, okay, that's fair game. If you, after being fired, ask an employee at the company to take computers and delete stuff, that's fair game. But some of this other stuff, let's inflame the jury's heart by telling them that he beat up his brother during a meeting. I don't see how there is a balance there on that.
Well, threatening behavior, again, goes directly to demonstrating his ability to put his own self-interest at the expense of others, and that goes to the heart of honesty and integrity. The fact that there were many of these acts only indicated how defendant chose to live his life.
Yes, and counsel, you know what? There are trials every day where we have defendants who have a rap sheet a mile long. A mile long. They'll have 20 felony convictions on their rap sheet. And I see no judge say, go ahead, go to town on all of them, because they don't let you go into the facts. They usually just let 1 or 2 in. I mean, there is a balance.
But looking at what was let in relation to its impact on whether the jury could otherwise decide the case, not based on the fact that this is just a horrible person. That's really the balance, not what was let out.
That's correct, and perhaps if this involved a case that had 100 or 150 allegations, it would present a different scenario.
38 non-convicted and they're not convictions, not one of them, acts. That's balance.
Well, as you point out, the fact that they're not convictions, that they're just bad acts, if anything, makes them less prejudicial. But the fact that there were so many is only indicative